Item number 1, number 7688, sub A.
Chairman Keeble.
Thank you, Mr. Speaker. House Bill 7688, Substitute A, by Representative Canario, greatly improves the state of Rhode Island's ability to deal with society's most troubling issue: how to deal with the carnage we see all too often as a result of gun violence. And how do we do that while balancing our obligation to protect our citizens' rights pursuant to the Second Amendment to the U.S. Constitution and Article 1, Section 22 to the Rhode Island Constitution? I believe this bill does just that by striking at the heart of the problem: mental health issues. 7688 Substitute A provides that the Superior Court may issue an extreme risk protection order upon a showing of specific facts that the respondent poses significant danger of causing imminent personal injury to self or to others. An initial order enters upon a showing of probable cause. Within 14 days, the court shall hold a second hearing, and the state must meet its burden of proof by a clear and convincing evidence standard. That is a very high standard. That second order, if it is issued, is good for 1 year. At any point within that year, the respondent may petition the court to have the order removed. At that hearing, the respondent bears the burden of showing that the order should no longer stand by the same clear and convincing standard. All of this must be done with credible evidence and by sworn affidavit. In order for the court to extend the order past 1 year, there must be another hearing where the petitioner needs to show by clear and convincing standard that the order should remain in place. In addition, within 30 days of the order expiring at the 1 year mark, the court must hold a review date. There is also an appeal to the Supreme Court. If the order issues, a search warrant also issues that allows the police to search and remove any guns within the custody, possession, or control of the respondent. I believe this bill is narrowly tailored, as any bill restricting gun ownership should be, to effectuate the goal of removing guns from those who are displaying clear signs of mental health issues that would warrant restricting that person's right to have a gun. Furthermore, we know from the experience in Connecticut, which has a similar law, that these proceedings are used sparingly and only for truly good cause. Mr. Speaker, I move passage.
Chairman Keeble moves passage. That is seconded by Representative Morin, Chairman McNamara, Chairman Corvese, Chairman Asanaro, Representative Messier, Representative Diaz, Representative Slater, Representative McLaughlin, Representative Marshall, Representative Tabone, Representative Cunha, Representative Shanley, Whip Edwards, Representative Coughlin, Representative Blazejewski, Representative Johnston, Representative Walsh, Representative Hearn, Representative Canario, Representative O'Grady, Chairman Abney, Representative Donovan, Representative Rangland-Vassell, Representative Carson, Leader Shakachi, Representative Casimiro, Representative Regenberg, Representative Amori, Representative Tanzi, Chairwoman Ruggiero, Representative Knight, Representative McEntee, Chairman Craven, Representative McCannon, Representative Maldonado, and Chairman Handy. Chairman Keeble.
Mr. Speaker, I do have one amendment on this bill.
Proceed.
I move LC 003029/7, and at the appropriate time I can provide an explanation.
Chairman Keeble moves Amendment LC 003029/7. That is seconded by Leader Shakachi, Chairman McNamara, Representative Marshall, Representative Johnston, Whip Edwards, Representative Canario. Proceed, Chairman.
Thank you, Mr. Speaker. Throughout this bill, we used great efforts to try to provide all the protections we could to gun owners. And this amendment furthers that and is another example of that. On page 4, line 18, we are adding the language, "and if eligible, the court shall appoint an attorney for you." Currently, the bill allows for someone that is possibly subject to one of these orders to go to the public defender's office solely for a determination of whether or not they meet the income requirements to have an attorney represented them. This is a civil matter, not a criminal matter, so the public defender's office would not represent them, but they have agreed to do the intake to evaluate whether the person should have an attorney appointed to them. And this amendment language adds that the court, if that person meets the requirements, will have an attorney appointed for him. I move the amendment.
The amendment has been moved and seconded already. On the amendment, do you want to be added as a second? Representative Agello, Representative Tanzi, Representative Knight, Chairwoman Ruggiero, Representative McCannon, Representative Diaz, Representative Coughlin are all added as seconds. On the amendment, folks, I've got 4 lights. I assume they're not on the amendment. You are on the amendment, Representative Chippendale.
Thank you, Speaker. Would the author of the amendment yield?
Chairman Keeble will yield. Proceed.
Thank you, Chairman. This appears to be a great amendment. I have one question for you, and the attorneys in the room will certainly know better. Is there enough time in the process for an individual who has to seek assistance through the public defender's office? Will there be enough time for them to have an attorney designated to them and make that relationship in that short time period prior to this hearing? We have 14 days.
I agree with you, Representative Chippendale, that it's not a lot of time, but it happens all the time in the criminal world. I don't see why it would be any different here.
Thank you very much. Thank you, Speaker.
Representative Rangland-Vassell on the amendment. Not on the amendment. Okay. We'll get back to you when we get back to the bill. On the amendment, are there any? Please shut your light off for now. Thank you. There are no other lights. Any other lights on the amendment? There are no lights on the amendment. All in favor? Clerk, unlock the machine. All in favor, please vote green. Those opposed, red. Clerk, lock the machine. 68 in favor, 0 opposed. The amendment prevails. Back on the act. Deputy Speaker Lima.
Thank you, Mr. Speaker. Members of the House, I have an amendment.
Proceed.
The amendment is LC 003-029/5. I move the amendment and I have an explanation.
Deputy Speaker Lima moves amendment LC 003-029/5. That is seconded by Leader Shikachi, Representative Constantino, Representative Solomon. Proceed.
Thank you, Mr. Speaker. Members of the House, this amendment provides for the return of confiscated firearms after the termination of any protective order. It must be effectuated within 10 days. It also says that the respondent shall not be required any additional court order granting the return, seizure, or surrender of the firearms, meaning that when the case is over or resolved, that the respondent, in a timely manner, 10 days, without having to do any other court petition, would have their firearms and their property belong to them. Thank you.
Whip Filippi, are you on the amendment? On the amendment, there are no lights. Anybody on the amendment? Clerk, unlock the machine. All in favor of the amendment, please vote green. Those opposed, red. Clerk, lock the machine. 67 in favor, 0 opposed. The amendment prevails. Back on the act. Whip Filippi.
Thank you, Mr. Speaker. Excuse me. Chairman Keeble, I felt, gave a great introduction to this bill. And one thing that I thought he said, which I appreciated, is that clear and convincing is a high standard. And when he answered Representative Chippendale's question, he said that 14 days is not a lot of time. So essentially, order is issued based on probable cause. It could be ex parte, meaning that the defendant, the respondent, is not there. He's not there to defend himself or herself. An order is issued, and then they have 14 days to have the full hearing before what is essentially a final order on the merits. The problem, it's a due process problem. Due process is lacking here because that defendant who's going to have their fundamental right to keep and bear arms taken from them has no ability to conduct discovery, to find out what evidence is going to be used against him or her, has no ability to do depositions, to send out interrogatories, requests for admissions, basic things that are used in the civil discovery process every single day to determine what your opposition is going to say about you. If you sued me for $10,000, I'd have the ability to depose you, to find out all the information that's out there, most of it, before we go to court and we ask the judge to issue a final order. In this case, we're denying that ability to people and taking away their fundamental right without giving them the opportunity to find out what evidence is going to be used against them. It's not fair. I like the red flag bills done right, and the devil is in the details, and there's a serious error with this bill, which I have an amendment to correct, Mr. Speaker. So I move LC 003029/6.
Webb Filippi moves Amendment LC 003029/6. That is seconded by Representative Newberry, Leader Morgan, Representative Price, Representative Natalittle, Representative Roberts, Representative Mendoza. Proceed.
Thank you, Mr. Speaker, and I'll give the body a second to read the amendment, if I could, please.
You may.
Thank you. Thank you to the body, and thank you, Mr. Speaker.
Proceed, Webb.
Thank you, Speaker. What this amendment does is it clarifies that a respondent who's about to have their fundamental rights taken from them has a right to conduct discovery. And it also provides that respondent with the right to postpone the hearing, the 14-day hearing, until their discovery is completed and they can adequately defend themselves in the 14-day hearing. And then the important thing in this amendment is it provides that the initial order depriving them of their firearms, that continues until the full hearing is had. So if a defendant says, you know what, I need at least 2 months to complete discovery, they get the 2 months. They have the right to demand that extension of the time, but that initial order stays into effect, so they cannot get their firearms back. And we can have a full hearing where the issue of their mental stability and dangerousness can be resolved. We should not be denying individuals the ability to conduct discovery before their fundamental rights are taken away, and we should not be denying the court the ability to fairly adjudicate that decision based on a full evaluation of the evidence. We are denying people the ability to evaluate the evidence by not giving them discovery and ordering them to a hearing in 14 days. This bill preserves this amendment preserves due process. I see no reason why it should not pass today. Thank you.
Thank you, Whip. Chairman Craven.
Thank you, Mr. Speaker. I'd like to address this amendment. I often find myself, as an attorney, trying my best not to talk like a lawyer. Sometimes I think it's appropriate and you lose the meaning of it. There's nothing in the original bill that doesn't require or allow the rules of civil procedure to apply. The problem is the practicality of it all. This is a proceeding that is scheduled by statute to happen in 14 days. How much can you do in 14 days? Well, if you really want to, you get it done. Sometimes that happens. I've tried many a case where I've worked nights and weekends in order to get it done. Why would we want to make a lawyer go through that? Because this is an extreme circumstance where there's guns involved and there's evidence of danger that the court finds preliminarily is sufficient to allow this petition to go forward. And I think when you, as we often do in the law, there's a balancing test that happens. We look at the problem that this person faces, this fear that they face, and then we look at the constitutional rights under the Second Amendment, which I believe in. And we balance that and we say, well, yes, we do have to observe those rights, but we better do it quick because there's a problem here. And my concern is, my experience has been people coming forward to challenge someone who's in possession of weapons is more likely than not someone that they know really well. And they're going out on the limb. They're taking a chance. And if anything at all, has a chilling effect, like 2 or 3 months of potential discovery, depositions, and even the deposing of the moving party or the concerned party themselves, that person might not come forward. And I'm willing, as the Constitution does, quite frankly, after 9/11, so did the Patriot Act. We suspended constitutional rules in order to prevent terrorism from attacking us. This is kind of a terrorism in some person's life. And I think that to delay it, or better put, to not leave it to the sound discretion of the 21 members of the Superior Court, every one of which I know, and every one of which, if I said I need another week, they would give it to me. I would ask the members to vote against this amendment, as I think it cuts to the core of the emergency nature of these types of proceedings. Thank you, Mr. Speaker.
Leader Morgan.
Thank you, Speaker. This amendment says that the temporary extreme risk protection order would continue in full force, meaning those folks would not get their guns back while they are collecting their evidence. One of the things that they may be asked to do is get a mental health evaluation or a substance abuse evaluation. That relies on other professionals. It may not be easy to do in 14 calendar days. This is not about giving the people their guns back while they're going through discovery and getting their case in order. This is about letting them have their rights to defend themselves. This is a good amendment because all of us, when we go to court and are going to lose one of our constitutional rights, should have the ability to thoroughly defend ourselves and to collect all the information and present it to the courts. To say that somebody would fail to come forward because they might be afraid they are going to be questioned, that's specious too. Our courts are built on being able to question your accusers. That's a legal standard that our courts are built on, that you're able to ask your accusers questions and confront them. And so now, in this case, we're not allowed to do it anymore, and we better damn well do it really quick. This is about constitutional rights and legal precedents that we should be upholding. This is a good amendment, and we should pass it. Thank you.
Representative Newberry.
Thank you, Mr. Speaker. I want to address Chairman Craven's practical questions. I understand where he's coming from because, like him, I practice in Superior Court all the time, and he's right that the rules of civil procedure and the discovery rules are very hard to get done in any kind of expedited fashion. Certainly 14 days is a short time. Can it be theoretically done? Sure it can, but life tends to intervene. As Whip Filippi pointed out, though, this would continue the order in effect. So the artificial deadline that we're talking about is one that we're putting in the statute. There's no practical reason why other than the chilling effect, which I don't agree with that. I understand what you're saying. I don't think that outweighs the constitutional rights here. But there's no practical reason why we have to put this artificial deadline on this if the order will stay in effect. And while I respect the judges of the Superior Court as well and their judgment, I don't think this statute as written gives them the discretion to delay the hearing more than 14 days. It actually says shall schedule within 14 days. Now, we all know judges might do what they want to do, but that's what the statute says. I don't think there is discretion. But my last point, I don't want to step on another amendment, assuming this one fails, which I'd be shocked if it didn't fail. Another amendment that's coming up, and I want to step on Rep. Chippendale's amendment coming up, is even after the 14 days, a petitioner can still come back within up to the time for a year to make their case why they should be able to get their guns back. So that chilling effect argument that Representative Chairman Craven was making is going to be in effect anyway up until the time that rehearing occurs. That could be months down the road. So in short, I don't think the arguments Chairman Craven made, while well-spoken, as a practical matter, actually apply here. I see no reason why this amendment shouldn't pass.
Chairman Craven.
Thank you, Mr. Speaker. If I can address some of the points that have been brought up by Leader Morgan, specifically, we're not chilling anyone's opportunity by this bill to present evidence. Evidence can be presented and is expected to be presented. Witnesses, I would expect to be subpoenaed. People will be questioned under oath, as is the case with the deposition. Why do depositions happen? Because lawyers try to figure out what's going to happen, and usually that's why civil cases settle. That's where the depositions typically take place. But as far as, something happens where a person really needs an opportunity to do a deposition or to engage in some form of additional investigation, if you look at page 5 of 14 in the bill, the last line, 34, begins with, "The court may continue a hearing under this section upon a showing of good cause." That is the flexibility that the Superior Court has, and I would maintain that even if that language wasn't in this bill, there isn't a Superior Court judge who would see something that amounted to good cause and wouldn't react to it and give you time to respond to it. And as far as the 14-day deadline, yes, it does say that it shall be called, so to speak, in 14 days, but it doesn't mean it has to end then. There are many times in the midst of civil trials where you have a jury waiting, where you conduct emergency depositions of doctors who can't arrive. That's not unusual. So all this does is it takes the process, provides a process for folks to exercise their concerns and bring them to court about this red flag legislation, and have an opportunity to have that done quickly, so that the chilling effect I believe is the case. I've seen a lot of people in my 35 years who were deathly afraid of the people they lived with or lived near or were involved with their life. And I mean deathly afraid. And these are people that it takes a lot of moxie to come forward and file such a complaint like this and ask the Superior Court to take action on a restraining order with someone with guns. Because if you're wrong, and I'm looking at Ray Hull here, you know Ray, if you're wrong, the answer is permanent. You're dead. Thank you.
Chairman McNamara.
I'll pass.
Chairman passes. Leader Morgan.
Thank you, Speaker. I can imagine somebody never having had any trouble in their lives. They don't know any lawyers. They've never had a police officer show up at their front door, come in with a search warrant, seize their property. They're in disarray. It would take them days just to figure out where to go and where to go, and who to ask, and how to get themselves together. Then you take Saturday and Sunday out. They could be down to very few days to get a mental health evaluation, to get all of their evidence and their discovery done. This is a very short period of time. This is a good amendment. This protects people's rights. I know when you're a lawyer, you think it's pretty easy to navigate the legal system. It is not, especially if you've never been in trouble before and you're not expecting a police officer to show up at your door one day and take your belongings. It's a good amendment. We should pass it. It doesn't weaken the bill, it makes it better.
Representative Blazewski.
Thank you, Mr. Speaker, members of the House. I want to point out another technical issue. If you look at another reason why this amendment is unnecessary, if you look at page 4, lines 19 through 21, it covers just the same situation that Chairman Craven discussed, which is that the hearings can be continued, the temporary restraining order would continue, and if a court considers it necessary to allow discovery within its discretion and with good cause shown, that temporary order will continue. So for other reasons, the bill already covers much of the issues that Rep. Filippi has risen, and I urge defeat of the amendment. Thank you, Mr. Speaker.
Representative Chippendale.
Thank you, Speaker. While I certainly have respect for all of the practicing attorneys and their relationships with the judges on all the different benches, I think that's completely irrelevant because those judges aren't going to be there forever. They're human. And their experiences in the court may make them feel comfortable. But unless we articulate exactly what is being represented as already possible, unless we articulate it, I can't trust someone I don't know and their discretion, nor should anyone in this room. This doesn't harm the bill. It changes nothing, except it gives the respondent the right to face their accuser and a reasonable amount of time. I mean, I argue it violates the Fourth Amendment as well. It's an unreasonable seizure of my property. If I don't know why you're taking my property and you will not tell me, that's unreasonable. There are issues with this. This does not harm anything. That person in fear who made the complaint initially, they're safe because the firearms are removed from that potentially dangerous person throughout the entire process. All this does is ensure fundamental constitutional rights, common law rights that we have to face our accuser. I don't see why we wouldn't do that as a good body. It just doesn't make sense. Thank you, Speaker.
Deputy Speaker Lima.
Thank you, Mr. Speaker. Members of the House, I'll try to give you a non-legal, not being a lawyer perspective on this. But I wanted to address Representative Chippendale saying you're taking my property without telling me why. Well, that's not true because on page 4, lines 25 and 26, immediately when personally served by the petitioner, along with supporting documents that form the basis for the order, so the person knows exactly why and what evidence they have and what was presented to the court before that is done. But I just want to say, and I truly believe in the Second Amendment, and I appreciate the amendment that Rep. Filippi has put forward. And whenever it involves constitutional rights, we must be very, very careful not to violate that. But boy, I got to tell you, if it's me and I'm facing a possible 5 years in jail, or I'm facing a $5,000 fine, or both, for me to come forward and say, this person is dangerous, there must be a very strong, immediate, compelling reason for me to do that. And if I come forward to do that, I have to have my evidence, my written documentation, and then it would be the police that would file that. Then it would be going before a judge. I think this is an extreme situation. I was very concerned about this, but I would say that the language that we have now without the amendment gives a nice balance between those who are pro-gun and those who are anti-gun, so that we can do the right thing and protect society and protect the gun owner's constitutional right. So I urge you not to support this amendment for those reasons. Thank you.
Whip Filippi.
Thank you, Mr. Speaker, and I appreciate Representative Lima's, Deputy Speaker Lima's comments, but you could be wrong when you go in and make the complaint. You said that if someone goes forward and risks a $5,000 fine or a felony, that there must be something there, but you could be wrong. People are in jail who are innocent today. Courts make the wrong decision all the time. And I know many of the judges on the Superior Court too, and I think they do a heck of a job, but there's many times they're wrong. There's many times the Supreme Court even tells them they're wrong. The fact that my friend Chairman Craven used the Patriot Act to justify passing this bill, I think should give us all pause, and it's why we should pass this amendment, because if you remember, the Patriot Act was passed in the weeks after 9/11, and that took away a lot of our constitutional rights, especially our Fourth Amendment rights, that I think this country is still dealing with. So I think that comment actually supports this amendment. And I think Chairman Craven and Deputy Whip Blazejewski made good comments that the court may allow discovery and they may allow continuances, but we have debates in this room about may and shall all the time. And I think I remember having one last year about the Protect Families Act, which the judiciary is asking us to change because we may have passed that without looking at it properly, like I think we're doing now. The court may give you that relief. It doesn't have to. Courts make bad decisions all the time. Let's give the person the right to discovery. It's simple. If you sue me for $10,000, you get discovery, I get discovery. We get to figure the whole thing out. But if you're going to take away my constitutional rights, I don't get it. That just doesn't make sense. The guns are out of the person's hand. The extreme danger's gone. Let's give them fair due process before we take away their firearms for a year. It's just simple. Thank you.
Representative McLaughlin.
Mr. Speaker, members of the House, this is a very controversial issue, and, I'm looking and I'm saying it's a hard thing. What it boils down to basically is an issue of mental health, and a lot of it is he said, she said, or he said and he said. Yeah, for a person to actually have his weapons removed. But I've seen a case a long time ago, a good friend of mine, okay, in civil domestic courts, and you've probably seen it, Chairman Craven, and where a person will go before a judge, okay, and the wife will say, he tried to strangle me, okay? Next thing you know, the judge looks at him and says, guess what? You're removed from the house. Here's an order. And basically it could be just the other side. So I think with that said, I think we should give this person who has a mental health issue, basically every right to redress the argument or the charge that's been brought against him. 14 days, the guns are still confiscated. You know what I mean? This person is no longer basically a threat, all right? But his rights or her rights, to ascertain every legal outfit, or whether it be psychological examination, psychological exam, which could take up to 3-4 months of testing, okay? This person should be given that ultimate right, That's my opinion, that's all. Thank you.
Leader Shekarchi.
Thank you, Mr. Speaker. I appreciate the very passionate debate on a very sensitive and important topic. I just want to state that I think Chairman Craven, Deputy Whip Blazejewski eloquently stated the reasons why this amendment is not needed, because the bill already has those protections. We leave it up, as we do in every single law we pass in this chamber, to the discretion of a judge. It's called separation of powers. I think that we have an excellent Superior Court, and I trust their judgment, and there also is an appeal from the Superior Court if someone felt they were infringed at that level. For all those reasons stated, I urge defeat of this amendment. Thank you.
There are no other lights on the amendment. Clerk, unlock the machine. All those in favor, please vote green. Those opposed, red. Clerk, lock the machine. 12 in favor, 53 opposed. The amendment fails. Back on the act. Representative McLaughlin.
Sorry, I pressed the wrong button. I should have been in the negative, the affirmative on the amendment.
You voted in the
The negative,
negative.
it should have been in the affirmative.
You would like it changed to the affirmative?
Yes.
So ordered. Back on the act. Representative Chippendale.
Thank you, Speaker. Just one general comment is I've heard a recurring theme of mental health, mental health. This is not strictly about mental health, nor should it be. There are myriad reasons, and they're articulated in the bill on page 5, that should be considered by the court. And they aren't all strictly mental health, and again, nor should they be. So let's not just couch this as just a mental health issue. This is far broader than that, and again, it should be. I'm a little disappointed on the passing of that last amendment, failing of that last amendment, but not surprised. But more so, I look in other places in the bill, Speaker, and I see things that, again, I am not an attorney. I don't have experience, but I can read this and feel a little bit concerned about certain steps. And we see in this legislation that there is confidentiality. Any proceedings under the chapter, etc., all matters filed under this chapter, all matters, as well as any document submitted in conjunction with the proceedings under this chapter. That means all the information furnished to the police for the affidavit, by the police for the affidavit to the court, shall be maintained as confidential and non-public by the Superior Court. So what does that mean? The folks who advocate passionately against domestic violence have been able to articulate the history of abuse orders. So they're able to see whether it's working or not, and they present that information in a hearing. It's extremely beneficial for those of us who have to make the decisions when dealing with domestic violence laws. If these are sealed in such a way as prescribed in this bill, how are we to measure the efficacy of this? How are we to ascertain whether or not there's abuses? How do we make any sort of assessment if only the Superior Court controls that? And I know everyone on the Superior Court's a great person. I get it. I know. And you all know them, and they're all great. But they're going to die, and they may not be great in the next time around. Things change. This law won't change. This will be in the books. Why would we make this confidential? We don't make protective orders confidential. Restraining orders. We need to be able to assess what we did. And this bill does not allow that. I have 2 amendments. I could have had one for this, but I don't, because honestly, you can only do so much with the amendments. But this is a huge flaw. This is a huge flaw. We will never know if there's abuse of this. We will never know if it's even working. And that's problematic. If that does not chill people in this room, well, I'm not going to say what. Thank you.
Representative Rangland-Vassell.
Thank you, Mr. Speaker. To my worthy colleagues, I stand in full support of this bill. Today is a great day for Rhode Island teachers, students, and mental health and people with mental health problems. I'd like to take a moment to thank the sponsors of this bill. It is a great bill, a bill that's needed for so long. The red flag bill is a good first step. It really is. But we're not there yet. It's important that we continue this trend. It's important that we pass the assault weapons ban. It's important that we pass.
What is your point of order, Whip? You are absolutely correct. Please stick to the four corners of the bill and what's in the bill. The bill's on red flag.
Thank you.
Thank you, Whip. Thank you, Representative.
Thank you. I think it's important for people that have been fighting this fight to make sure that we pass good common sense gun control laws. I think this is a good first step. We cannot stop. This red flag bill, while it's good, it's exciting for all of us, it's not the end of this fight. We must make sure that we have good jobs. We're still talking about the red flag bill. We must make sure that we support families. Thank you, Mr. Speaker.
Well, hold on. She's talking about families and economic conditions which are somehow connected to behavioral health issues, so I'll give you some leeway. Proceed.
Thank you. I think it would be short-sighted for us to just think that just passing this red flag is going to do it, because it's not. Like I said, it's a good first step, and I applaud the sponsors, but we must continue this fight. I see students every day who have issues, and the issues are brought about in many instances by poverty. And what I am standing here today to do is help all of us connect the dots. The dots that gun violence is connected to poverty. A lot of the mental health challenges that people have is connected to poverty. So thank you, Mr. Speaker.
All right, your point of order is sustained. Thank you. I tried to give as much discretion as possible. Please stick to the merits of what's before us. Thank you all. Chairman McNamara.
Thank you, Mr. Speaker and ladies and gentlemen of the House. I stand in strong support of this legislation. And, Mr. Speaker, I have a brief description of a murder that took place that my family was victimized in, and it is a prime example of how this legislation could have saved lives. On June 17th, 1978, I dropped my nephew, who was 6 years old, off at my mother's house. They went to dinner at a restaurant in Warwick called Cathay Terrace. My aunt and uncle joined them. A cook at Cathay Terrace by the name of Chin, who was well known to the Warwick Police Department due to his behavior, walked out of the kitchen with a pump shotgun, at point blank, shot the bartender, moved down, shot the owner. My 6-year-old nephew said to my mother, "Grandma, let's run." She said, "Please get under the table." They were under the table with my aunt and uncle, my godparents. He proceeded down through the restaurant, boom, another victim, and finished at the cash register, where a woman by the name of Dorothy Johnson, who was 6 months pregnant, point blank, boom, dead. My aunt and godmother was there as she dropped next to the table, had a coronary, and died. This individual ended up spending 10 years at the forensic unit and died there. It is an example of what this legislation could address. Known to the police, and I'm not diagnosing this individual, known to have some behaviors that were very, very unusual and dangerous. So I would ask that in memory of those 6 victims that could have been helped, and what I call a mass murder that has long been forgotten in Rhode Island and not been brought up, that yes, it's about time that we pass some common sense laws to address this carnage. Thank you, Mr. Speaker.
Representative Lombardi.
Thank you, Mr. Speaker. If there's no objections, I'd like to be recorded in the affirmative on the first amendment.
You may, so ordered.
Thank you.
Representative Chippendale.
Thank you, Speaker. If it's appropriate, I'd like to introduce an amendment.
It's appropriate. Proceed.
Thank you. It's LC 3029/2.
Representative Chippendale moves Amendment LC 003029/2. That is seconded by Representative Newberry. Proceed, please.
Thank you, Speaker. On page 7 at the bottom, the last section, which is termination, expiration, renewal of orders, the very first section, very first few lines in there, lines 29 through 31, termination of order. The respondent may submit a single written request for a hearing to terminate the order within 12 months within a 12-month period. A single. That means just one. So in reading the bill in its totality and understanding how the procedure works, we can learn on page 11 in the liability section, which is lines 17 through 21, we learn that there is no liability for omissions related to obtaining the order, reporting, declining to report, etc. There's indemnification there. If information's withheld, and I somehow learn about that information through some organic process and realize, well, wow, this videotaped confession of my accuser saying that they lied certainly would have helped me. But I already had my one, as prescribed in this bill, my single request to terminate. But when they got the order, they had this information and it wasn't presented, as the bill clearly states. I think we should be able to then, upon learning new evidence, represent an appeal. If you didn't have all of the information when you made an appeal through the normal process as prescribed by this law, you shouldn't be denied the right to have an appeal if more information is discovered. So with that in mind, and I think the amendment itself reads quite simply, we are adding after that, the language, existing language, unless the respondent can demonstrate the existence of newly discovered evidence not available to the respondent at the time of the original proceeding, which would support a request to terminate the 1-year extreme risk protection order. This puts no one in danger. No one. This is only if new evidence is discovered and is presented to the court. We're simply not saying, hey, you get one bite at the apple and that's it. That's certainly not fair, especially in light of, in this case, the discovery of new evidence. And I will let the assassination commence. Thank you.
Whip Edwards.
Thank you, Mr. Speaker. Members of the House, as Representative Chippendale so eloquently pointed out, he says there's only one bite at the apple, when there are in fact 3. And Representative Chippendale is attempting to get a 4th bite at the apple. The first is when you have your hearing. It is brought before the court, and it is the petitioner who has the burden of proof. The second is any time during that first 12-month period, a person can bring a hearing forward and have this looked at again. And then at the end of the 12-month period, there is another hearing that deals with this. So, as Representative Chippendale said, there's only getting one bite at the apple. He is trying to get a fourth. This is not a good amendment. It is contrary to the intent of this legislation, and I urge all my colleagues to vote it down. Thank you.
Leader Morgan.
Thank you, Speaker. It's not often I agree with the ACLU, but this is one of them, because the ACLU is the one who actually has said that this is a violation of due process. They have flagged this as a violation of our rights. I'm not sure if that last one that you said was a third bite is actually a third bite. It's a hearing to see whether it's going to be renewed. And in that hearing, there is a reversal of the burden of proof onto the respondent. He has to prove that he should get his guns back rather than he's guilty. So that's kind of a reversal of all the things that we think about in our court system, that you are innocent until proven guilty. Not in this case, because now you have to prove that you're not guilty. It's a really bad reversal of the burden of proof. Seriously, this is a good amendment. It protects people. It gives them due process. If sometime in 12 months you find out that there's new evidence, why shouldn't you be allowed to go to the court and ask for a hearing? Doesn't that make sense? Nope, sorry, we're full. You can only do it after 14 days and one other time. We don't care what you find out. We don't care if there's something else that comes to bear on your case. Nope, we don't want to hear from you. That's a real violation of rights. I understand. Very eloquent story here. We want to keep guns out of the hands of people who are a danger to themselves and others. We do. But we can't do it with a flawed piece of legislation. That's not fair either. Thank God there are very few people like that demented person at the Cathay restaurant. Should we trample on the rights of so many others when we can cure this legislation and make it better? This is a good amendment. It makes this bill stronger, doesn't weaken it. It doesn't give somebody their guns back willy-nilly. They have to prove there's a reason, that there's a circumstance that has come to light. This protects rights. It makes our law more responsive to individuals in our state. We should adopt this. Thank you.
Representative Blazewski.
Thank you, Mr. Speaker, members of the House. I would like to point out here that there was some discussion about the burden flipping and with the renewal at the 1-year mark. That's simply not the case under the legislation. If you look at, again, reading the actual bill, page 8, line 24 and 25, it's actually 28 and 29, that the burden at the 1-year mark is on the petitioner to present clear and convincing evidence to continue the protective order for another year. So it's not that once you get that protective order, you're stuck having to show clear and convincing evidence. It needs to go away. At the 1-year mark, the petitioner has to continue to show clear and convincing evidence. So for that reason, I again urge defeat of this amendment. Thank you, Mr. Speaker.
There are no other lights on the amendment. All those in favor, please vote green. Those opposed, red. Clerk, unlock the machine. Clerk, lock the machine. 12 in favor, 55 opposed, The amendment fails. Back on the act. Representative Newberry.
Thank you, Mr. Speaker, ladies and gentlemen. I actually think that red flag legislation is a good idea. I think this chamber should pass red flag legislation. I think every state in the country should. I don't think this bill is good enough, and I will not be supporting it, but I want to explain why. I've given a lot of thought to this because the Second Amendment to the Constitution is the right to bear arms. I know some people don't want to hear that, but it's there for a reason. And I'm not going to get into the whole history of it and why it's there. But it's co-equal with a lot of other constitutional rights that we often debate in this chamber. The right to free speech under the First Amendment, the right to unlawful search, against being subject to unlawful searches and seizures under the Fourth, the right to counsel, which I believe is under the Sixth, the right to due process under the Fifth. And what I find sort of interesting about debates on gun legislation is how many people, and I don't just mean this chamber, I mean in the public, sort of view things differently because it involves guns. See, to me, if you're going to defend the Bill of Rights, you need to defend the Bill of Rights. You don't get to pick and choose which ones you care about. If the bill before us today were to impinge upon our First Amendment rights, this would be a very different debate. If it were to impinge upon our Fifth Amendment rights, it would be a very different debate. And the reason for that is because something about guns triggers people to focus on as the story Representative Chairman McNamara told about, some of the horrors of it. And I understand that. But to me, and by the way, let me be clear, the constitutional rights are not unlimited. The First Amendment's been circumscribed, the famous you can't shout in a theater, not a crowded theater, by the way, just a theater. Obviously, libel laws are an exception to First Amendment rights. There are exceptions to right to counsel and so forth. And there are exceptions, even the Heller decision from the Supreme Court from, I think it was 2008, which is the leading case on Second Amendment rights, makes it clear, Justice Scalia, that there are exceptions to the Second Amendment. I don't think this bill, for example, is unconstitutional. But I think we have a duty as a legislature that we're going to pass legislation which does infringe upon someone's constitutional rights, particularly in the Bill of Rights. And it's ironic, by the way, in Rhode Island, of course, we were the last state to join the United States after the Revolution, in part because the colonial government at the time demanded the inclusion of the Bill of Rights in the Constitution. I think if we're going to pass legislation that impugns on or limits people's constitutional rights, we have a duty to make sure we're doing it in the least intrusive and best way possible. Do I think the bill before us is terrible? No, I do not, but I think it can be improved. I know we can improve it. I don't see any reason why we don't. I know a lot of legislation in this chamber gets negotiated between people before it hits the floor, and that's fine. That's how legislative bodies work. But I'm disappointed that this bill was not better, because there is red flag legislation in the United States that's better than this that we could adopt, and I would support it if it were there. We've already seen some examples of it, and Mr. Speaker, if I may, I have an amendment I'd like to move at this time.
Proceed.
I'd like to move LC 3029/3.
Representative Newberry moves amendment LC 003029/3. That is seconded by Representative Chippendale, Representative Price, Whip Filippi, Lita Morgan, Representative Roberts. Proceed, Representative.
Now, I'll admit this is a small but telling example of what I'm talking about, how we can improve the bill, but there's any number of them, and I'm not going to, I could have drafted up a dozen amendments, I didn't, I'm not going to. But this is a civil proceeding we're talking about. Let's put ourselves in the real world here for a minute, as Chairman Craven wanted to talk about in the other amendment. Put ourselves in the real world. Somebody comes to the court. Typically, it's going to be the police upon complaint by someone, and maybe the police themselves. They come to the court and they present probable cause evidence that someone is a danger to themselves or a danger to the community, and they want to enact this statute. And that's fine. But it's still a civil standard. And if you're a judge and someone presents you essentially ex parte with evidence that someone's a danger, the odds you're not going to issue the warrant for probable cause to at least seize the weapons, even though there's the 14-day hearing and all that, are pretty slim. It's not the same standard. I don't think it'll be treated as the same standard for a typical warrant for criminal conduct. And why does that matter? Because what's going to often happen, I suspect, I don't say often happen, but what may well happen to people is the police go in to seize weapons and they come across other contraband. They may come across drugs, for example, just to use as an example. They may come across evidence of other criminal activity. Now, here's the issue with this. We don't make laws, of course, to protect criminals. We all know that. That's not the point of making laws. But we do make laws to protect law-abiding citizens against being falsely charged, and we also make laws to make sure that people who are accused are given proper due process. All my amendment does is make sure that if there's ancillary evidence found during a lawful search, it's not used essentially for criminal charges against that person. I don't think that's unfair. I think if someone has a reason to suspect criminal activity against someone, if the police do, they should go get a criminal warrant under probable cause for criminal prosecution. It's a small point, but I think it improves the bill. I think it better protects the rights of our citizens. And I would also add, I want to be very clear about this. I'm not suggesting law enforcement as a group would ever do anything improper, but people are human, and we structure our government and our laws under the understanding that people are human and make mistakes. If a neighbor suspects there's criminal activity next door, for example, but doesn't have any evidence of it, but they know the person has weapons and they have a grudge against the person, they may well go in and file a complaint under this statute, which is likely to be granted to let the search trigger, and then the person may be filed with criminal contraband. So I think this is a reasonable amendment. I would ask you to pass it.
Representative Blazewski.
Thank you, Mr. Speaker, members of the House. I rise again to oppose this amendment. I really don't think it's necessary, and I think it does more harm than good. Courts have, for decades, have been dealing with situations like this, where we have evidence that can be obtained as part of a search warrant that is in plain sight or exigent circumstances, and there are protections built into our system for defendants to try to suppress evidence, the fruit of a poisonous tree. So it would upset really decades of precedent under state and federal law, and is unnecessary. For those reasons, Mr. Speaker, I urge defeat of this amendment. Thank you.
Representative McKinnon.
Thank you, Mr. Speaker. I rise in opposition to this amendment as well. And it was a point that I was going to make on the main bill, but it's a point that we got to look at the language of the bill. And it's at 88.3.3a. These petitions can be filed only by a law enforcement agency. So it was just discussed that if a neighbor has a grudge, then the neighbor may go into court and file this petition. It can't happen that way. The neighbor with the grudge has to go to the police department. The police department has to agree to file this. Now, this also pertains to issues of privacy. And with the indulgence of the Speaker, I'm going to make the other point that I was going to make. We don't have, often many investigations by the police are indeed private. So we don't have a mechanism here to make this stuff public, but that's okay. There are many investigations by the police that remain private because nothing ever comes of it. So I think this is a very significant protection. It's an interim step, and you have to go to the police, similar to filing a report in a crime, and the police have the discretion to look at this, and it's their job to gather the evidence. Thank you, Mr. Speaker.
Whip Filippi.
Thank you, Mr. Speaker. And I believe Representative Newberry said that a neighbor would make a complaint to the police and the police would file the petition. As to the exemptions that Deputy Whip Blazewski spoke about, one of the exemptions is plain sight. So if a warrant is served and there's evidence of contraband or illegal activity not related to the warrant, but it's in plain sight, that comes in. That can form the basis for a criminal charge. We have to remember that when the police go into someone's house looking for firearms, they're not just going to walk around, oh, there's a firearm, maybe there's one. They are going to turn that house upside down. They're going to look in every nook and cranny of that house, under mattresses, in ceiling boards, in your attic, in shoe boxes. They are going to inspect every single inch of that house. So I think we just need to keep that in mind when we're considering this amendment, and that's why I think it's a very good amendment we should support. And one other ancillary topic, Mr. Speaker, is I get a lot of complaints, I know many of us do, about neighbors saying, oh, I think there's an illegal marijuana grow operation going on there. And I think this will lead to false allegations under this bill to have police go in and maybe start counting plants, put in there by upset neighbors, where the police put in there by upset neighbors. Thank you.
Representative McEntee.
Thank you, Mr. Speaker. I rise in opposition to this amendment and in total support of the red flag bill. I just want to mention that I got an email from a constituent of mine in Narragansett today, and they are having a community forum on safety in our schools. And she writes to me, as parents, we are scared. Our educators are scared, and our children are scared as well. Let's remember why we are doing this, because of what's going on in our schools, what's going on in this country. Parkland, that particular person who shot all those kids would have been, his guns would have been confiscated before it happened, and we wouldn't have lost all those children and teachers. And so let's get back to why we are doing this. We want to protect our Rhode Island children, people of all ages, but our kids are scared, and our parents are scared, and we're doing this for that very reason. So let's get to it and stop all of this about all these amendments. You're forgetting why we're doing this. Because there is good reason for the police to want to take the guns. It's an extreme risk. I mean, why would we question that? I mean, they have a hearing, but the police have to go through the usual routine on looking into why they want to take the guns away. But when I get an email like that, I'm telling you that is why we are here, and let's get back to that. Thank you, Mr. Speaker. Thank you, members of the House.
Representative Chippendale.
Thank you, Speaker. The reason we're here is to make good, sound decisions that don't contradict our oath of office, not to make emotional ones, and certainly this is an emotional issue for everyone. I have children in school. Many of you have children and grandchildren in school. Who doesn't this impact? We're not here to legislate on emotion. In fact, we're here to put emotion in one box, facts in another box, evidence in another, and deal with it all, and calmly, deliberatively, methodically come up with the best possible law to achieve what we're trying to achieve. In fact, responding legislatively to emails is irresponsible in that regard. I don't think that's how we should do it. We are still on the amendment. Thank you. We understand, and it was articulated earlier, we understand that people make mistakes. We have to build in accommodations for these things in our laws. We can't have a situation where an individual, and I understand the comments made earlier by my friend Rep. McKiernan, an individual can go to a law enforcement officer and express concern about their neighbor. That law enforcement officer would then be the person to file for the petition. So yes, that's how it works. But it can start with a neighbor, or a friend, or a family member, or what have you. And an officer who's responsible is not going to take that lightly. And he may be presented, or she may be presented with very, very strong evidence in his opinion that this person could be a risk. And this officer, in all good faith, can go down this road because it's the right thing to do. But that person could have fabricated everything. That can happen. And I know judges can sniff it out, and I know the police don't fall for that all the time. It happens. People are humans. We're opening a door. We're giving a search warrant to someone to go through an entire house, potentially based on a false accusation. If that doesn't warrant extra protection, we have one goal here. Get the firearms out of the hands of this individual until we can determine whether or not they are a threat to the general public or themselves. That's our goal. That's the entire goal of this good bill. It's not to have a dragnet. I chased an 8-pound bass for 3 years in a pond. I fished for him all the time. I could have got a net, dragged the whole thing, and gone through all million fish in there until I found that 8-pounder. But that's not how you do it. That's not how we should be legislating or catching bad guys. We don't arrest everyone in the room, search them all to find the bad guy. We're opening that can of worms with this. It's a low standard, and it's a low, I understand, clear and convincing evidence. We, and all of the practicing attorneys will agree, I'm certain, and the law enforcement officers retired in this building, a law enforcement officer in a court is always going to err on the side of caution. It's a responsible thing to do. It's the human thing to do. If they believe there's an issue, they have to take it seriously, and I don't think they should do it any other way. That is lowering the standard.
Chairman, what is your point of order?
Yes.
Dealing with fruits of the search.
Yes.
Well, I appreciate
Mr. Chairman, use your microphone, please.
I believe we're still on Representative Newberry's amendment
You got it
dealing
right.
with the fruits of the search, and while I appreciate Representative Chippendale's passionate argument, I think he's gone a little astray from the amendment. His remarks would be more appropriate when we get back on the original bill.
I'm going to overrule you, Chairman.
Thank you, Speaker.
He's close enough. Proceed.
Thank you, Speaker. I was wrapping up anyway, and yes, I apologize for the fishing anecdote, but I was just trying to make a correlation to something that at least I can relate to. I believe we're opening a potential can of worms here. We're creating a low threshold on the side of safety where an entire house can be searched from tip to stern, and that should chill the people in this room. Thank you.
Representative McEntee.
Thank you, Mr. Speaker. I take extreme exception with what Representative Chippendale said about me being emotional and reacting to emails from constituents.
I did not specifically address the good representative. I said we should not legislate based on emotion.
Hold on, please. Let me address it this way without making a ruling. Let's all stick to the four corners of the bill and the amendments and not refer to each other. We should never refer to each other. Thank you, Representative.
Thank you, Mr. Speaker.
Representative McCannon.
Thank you, Mr. Speaker. Just to point out again, and I'll be brief, but after the police are notified and file a petition, then a judge looks at the petition and the judge issues the warrant. And the judge can limit that, certainly. So it's not the police deciding to go search a house, it's a judge ordering the house to be searched.
Last light, Leader Shikachi.
Thank you, Mr. Speaker. Again, another very spirited debate on an amendment. I state 2 points of fact. While the issues raised have a modicum of validity, that being said, you could raise those same issues for every single search warrant ever issued by the Superior Court. Second point I want to make is stated by Deputy Speaker Lima. There's a penalty, specific penalty of 5 years and $5,000 for false accusations. That in and of itself is a deterrent. I can appreciate and respect the constitutional arguments that have been made, but this amendment is unnecessary and I urge defeat. Thank you.
There are no other lights. On the amendment, clerk unlock the machine. All those in favor, please vote green. Those opposed, red. Clerk, lock the machine. 11 in favor, 56 opposed. The amendment fails. Back on the act. Representative Quattrochi.
Thank you, Mr. Speaker. Thank you so much. I would like to rise in opposition to this bill, and I'm going to come from a different perspective. Of course, I'm not an attorney. I'm an average person. But I can read pretty well. Article 6, Section 1 of our state's Constitution says it is the supreme law of the state, and any law inconsistent shall be void. Of course, Article 1, Section 22, which gives us our God-given, not government-given rights, not government-given privileges, contains 14 words. The right of the people to keep and bear arms shall not be infringed. In my vast research of the word infringe, I found synonyms which include restrict, limit, curb, check, encroach, undermine, erode, diminish, weaken, impair, damage, and compromise. Now, we've heard that this is a first step, a great first step. I'd like to say that if we were able to take the foundation of this building out in one swipe, that this building would collapse. Likewise, if we take one block of the foundation out at a time, eventually this building will collapse. So what is the second step? What will be the third step? What will be the fourth step? We are in dangerous territory, I believe, messing with our constitutions. As far as living in fear, I mean, for me to be against the red flag bill, does it make me a bad person? I have a daughter in middle school also. I don't live in fear. You could choose to live in fear. I don't live in fear. That's all I have to say. Thank you.
Representative McLaughlin.
Mr. Speaker, members of the House, I rise in support of the red flag bill. Yeah, as you've probably seen, I've tried to put every amendment, voted for every amendment for the protection, of individual rights and Second Amendment rights. But I would want to, this is not germane to the subject, but we talked about the shooting in Florida, which was a tragedy. An immense tragedy. But there was also a second shooting in Maryland, okay, where two children were killed, all right? And I look and I say, we were watching the TV that day, and my daughter teaches school in Maryland, okay? But we didn't hear what school it was. She started crying. I said, what's the matter with you? She said, listen to the news, okay? Some nutcase went in and blew away 2 kids, okay? And a resource officer with a weapon shot that individual, all right? But we need to take guns out of the hands of nutcases or mentally ill people, period. We need to do something. Thank you.
Deputy Speaker Lima.
Thank you, Mr. Speaker. Members of the House. We should never, ever violate a law-abiding citizen's constitutional right under the Second Amendment, and that right is to bear arms. I agree with that 100%. President Kennedy said today we need a nation of Minutemen, citizens who are not only prepared to take arms, but citizens who regard the preservation of freedom as the basic purpose of their daily life, who are not willing to consciously work and sacrifice for that freedom. But we have a problem, and we need to go address that problem without violating any law-abiding Second Amendment right. And that's what we're doing. We're approaching the problem where it belongs, with mental illness. You want to talk about, in 1994, I think 96, I put legislation for metal detectors in school. We need to make our schools safe, but not by taking away law-abiding citizens' rights. Let's get bulletproof glass. I mean, you can go into school with a gun, knives. One lady went and was going to hatchet all the kids. We need to protect the kids, but never by violating anybody's Second Amendment rights. If I was somewhere dangerous, I'd be grateful there was a good guy with a gun. We got to take the guns away only from the bad guys or those with mental illness. And in closing, I want to say something. With Parkland, Florida, what bothers me, more than bothers me, what angers and frustrates me, and it should every citizen, we all want to protect the kids. There were 30 incidences, 30 red flags where if actions were taken, that mass shooting would not have happened. But you know what? You know what? If this law that we have before us today was in place in Florida, then maybe some of those red flags, enforcement and the authorities would have realized they would have had to take action. There was enough red flags there that never ever should happen. And this law would help So let's never violate or look at just take guns for the sake of guns. It's not just guns. There's other things. They drive cars into people. We need to go after mental illness. We need to secure our schools. We all want the same thing. Let's not get emotional. Let's think clearly. What's the best way to do it without violating Second Amendment rights and with protecting people? So I commend all the people that worked on this legislation, sponsors, co-sponsors, you, Mr. Speaker. This is the way to go. We're going after mental illness. We're in the right direction. Thank you.
Whip Filippi.
Thank you, Mr. Speaker. And we should be taking guns away from people who should not have them. I think everyone agrees with that. The question is, how do we do it? And that's what I think the debate here has been about tonight. I think we have a strong disagreement about how it should be done. I don't think this bill does it properly. I don't think this bill respects the process which is necessary to take away someone's fundamental right. And for that reason, I can't support it. If we passed my First Amendment saying that we could do discovery, I would be supporting this bill. I think conceptually, it's a good idea, but we're dealing with a process which I think that doesn't offer the level of respect that one of our fundamental rights requires. And I assume this bill is going to pass. I hope we don't have to come back next year and fix it. Thank you.
Lita Morgan.
Thank you, Speaker. You know, 2/3 of the gun deaths in the United States are suicides. For a long time, people ask why. Why are people killing themselves? Somehow we think that passing another law is going to stop it, when for decades and centuries, we've never been able to figure that out. But another law is going to do it. I think a red flag law is a good idea, and we've endeavored today to make this one better. Because we all want to stop people from hurting themselves or others. I think we grapple with that. And yet, here we've had an opportunity to take a bill with flaws and make it better, and we've said no. You know, last year we had the misdemeanor bill, and we said, there are flaws in this bill. We rammed it through anyway. And now the courts are coming back to us and saying, please fix it. We can't work with this. It's making a mess in their courts. It is trampling on people's rights. We have an opportunity to get this right, to accomplish what we want to accomplish. But we shouldn't be passing a bill that is flawed now to do it. Should we be securing our schools? Yes. Should we be working with mental health advocates? Absolutely. But we shouldn't be passing bills that have flaws in them just because we want to say that we're doing something. We should defeat this bill and get it right. Thank you.
Representative Tienzi.
Thank you, Mr. Speaker. I'm very glad that the issue of suicide was brought up because this was an issue that I was interested in legislating on when I attended a seminar this summer, and the main focus of the seminar that I attended was on suicide prevention. And the minority leader is absolutely correct. 2/3 of all of our gun deaths are in fact related to suicide. And the best thing about this bill is that it offers these individuals the opportunity to go on and live full and complete lives. Here are some statistics that you may find helpful. 9 out of 10 people who attempt suicide and do not complete suicide go on to never attempt again. They live full, complete lives. Imagine that. Now, those who attempt suicide with a handgun, 9 out of 10 of those individuals do not survive. Take one piece out of that equation. Take the handgun away from that person who is in a momentary moment of crisis and can't see through to the other side of it. You have a gun in that equation, 9 out of 10 don't survive. You take the gun out of the equation, 9 out of 10 go on to live full, productive, happy lives. There's no better reason to support this piece of legislation than to allow 9 out of 10 people to go on and live the full lives that they deserve. I support this legislation wholeheartedly. I lost my best friend in high school to suicide with a gun. Her family had a gun in the house. It was not secure. She knew how to get it. She could have survived that moment. It was a high school moment. She could be here today. She could have a wonderful family like I have a wonderful family. She deserved that. It was a momentary crisis, and she unfortunately had the wrong equation put in front of her. Don't allow this to happen to other individuals. That's what this is about. 2/3 of gun deaths can be prevented, and that's what this is about. Thank you, Mr. Speaker.
Representative Price.
Thank you, Speaker. It's a very important issue. What's going on in this country now, where we're going as a society, and how things are happening. I understand that we're reflecting on this from the Parkland shooting, of so many of the other shootings, and the failure of government to address this thing. I'd just like to address how we as a government body are addressing this situation. I've been sitting through the committee hearings for this bill, and just recently, just the other night, Tuesday, we get a very drastically different bill than what we've been addressing. And now on the House floor, we're having some good amendments, some good testimony. We're having constitutional comments. We're having comments that this won't go far enough and will keep going, and even after this. Should this thing be jammed through in like just a few days, when it's not, when the professionals don't get a chance to address it, when the lawyers and the people don't get a chance to sit down and talk about this, when 75 of us are gonna talk about it in a matter of one evening or since Tuesday, and try to decide what's going to go on with this? I think that it's an issue that needs to be addressed, but do we want to rush into this issue? Do we want to make the process work, and do we want to work the process for the best of the people and for the best of everybody, so that it's constitutional, so that it protects people, and so that it's a good bill, a good law, and we don't have to come back and address it next year? Thank you.
Representative McCannon.
Thank you, Mr. Speaker. I'm not going to reiterate the points that I've made, but I do think this is a very good bill. But I want to follow up on a couple of comments recently made. There are many perspectives to gun violence. Rep. Tanzi brought a very emotional point, and I want to follow up on that. We look at these school shootings and these massacres, and it shocks us. But most gun violence happens on a more personal level. It's one person. In many cases, the loved ones of the person can see it coming. And I just want to point out that this bill, we've been looking at it like somebody against somebody may file a police report. I'm willing to bet that 90% of these reports will be from loved ones looking to stop something before it happens. And I just want to say, I think this is a very good bill because it works in that way. Thank you.
Representative McLaughlin.
In conclusion, I just want to say, again, please support this bill, because 20 minutes later, we get a phone call from my daughter, okay? Her school was locked down. She said, "Dad, I was scared. My students were scared." okay? What the hell do you do? You know, when you got no place to go. So let's keep the hands out of people with, you know, mental ill problems. Thank you.
Representative Canario, last slide.
Thank you, Mr. Speaker. Mr. Speaker, I am very proud to have sponsored the red flag bill with your support. This bill will save lives. Mr. Speaker, as you know, some time ago we were approached by the Rhode Island Chiefs of Police who brought forth ideas to curb school gun violence and mass gun violence. Who knows better about this topic than all the chiefs of police in the state of Rhode Island? As a former law enforcement officer of 25 years, I know firsthand how important this bill is to not only each other, but children, anyone in public places that that may be in harm's way. This gives law enforcement the tools necessary to intervene at a very crucial time. A time where an individual may at any moment take his or her weapon into a public place and cause serious harm to many people. We heard this bill in committee, and we made several changes to the bill in committee to make it better. As the professional law enforcement community has alluded to us, this is the bill that is needed to protect everyone. This bill does not trample on anyone's Second Right amendments. This bill will help save lives. We do not want to witness what has happened at other locations around the country when clear signs of tragedy was put forth by the respondent. Whether it be through social media or through friends, these people would put forth thoughts that they are having about committing heinous crimes. This bill will help us stop that. This bill will save lives. I urge all my colleagues in this chamber to please vote green on the red flag bill. Thank you, Mr. Speaker.
There are no other lights. Clerk, please unlock the machine. All those in favor, please vote green. Those opposed, red. Clerk, lock the machine. 60 in favor, 8 opposed. The act prevails. Next item, clerk.
Item number 2, number 7075, sub A.
Chairman Keeble.
Thank you, Mr. Speaker. House Bill 7075, Substitute A by Chairman Craven would make possession of bump stocks, binary triggers, or trigger cranks punishable, or other items that have the effect of turning a semi-automatic weapon into an automatic weapon punishable by up to 10 years imprisonment and/or a $10,000 fine. This clarifies and expands upon some laws we already have in the state. The bump stock is, of course, the item that was used in the Las Vegas shooting was one of the things that made it so deadly. It's a good bill. I move passage, and at the appropriate time, I also have a technical amendment, Mr. Speaker.
Chairman Keeble moves passage. That is seconded by Representative Hull, Representative Moore, and Representative McLaughlin, Representative Messier. Chairman McNamara, Representative Diaz, Chairman Azanaro, Representative Slater, Representative Tabone, Representative Cunha, Representative Shanley, Whip Edwards, Representative Coughlin, Representative Maldonado, Representative Casey, Representative Johnston, Representative Blizczewski, Representative Agello, Representative Walsh, Representative Hearn, Representative Canario, Representative Constantino, Chairman Abney, Representative Donovan, Representative Carson, Representative Casimiro, Representative Regenberg, Representative Amori, Chairman Handy, Representative Tanzi, Chairwoman Ruggiero, Representative Knight, Representative McEntee, Representative McCannon, and Deputy Speaker Lima. Proceed with your amendment, Chairman.
Thank you, Mr. Speaker. During the committee process, Minority Whip Filippi caught a typo on page 4, lines 20 and 21. We mistakenly called a trigger crank a crank trigger. This would merely rectify that. I therefore move passage of LC 003045/2.
Chairman Keeble moves amendment LC 003045/2. That is seconded by Whip Edwards, Representative Coughlin, Representative Johnston, Representative McLaughlin, Representative McEntee, and Chairman Craven, as well as Representative Marshall and Whip Filippi. There are no lights on the amendment. Clerk, unlock the machine. All those in favor, please vote green. Those opposed, red. Clerk, lock the machine. 68 in favor, 0 opposed. The amendment prevails. Back on the act. There are no lights. Clerk, unlock the machine. All those in favor, please vote green. Those opposed, red. Clerk, lock the machine. 65 in favor, 3 opposed. The act prevails. Next item.